Rights of a person accused of a crime. The Sixth Amendment has specific rights for criminal defendants, including the right to be tried by jury, the right to be tried in a timely manner, the right to be informed of the nature and all causes of accusation against you. Now, I will explain these rights in detail. Number 1, the right to be tried by jury. The judge must be fair. They can't be biased against the person during trial. For example, a judge can be involved in a case if the victim is a member of his or her family.
Number 3, the right to be informed of all the nature and cause of accusations against you. The Sixth Amendment guarantees defendants the right to be informed about the accusations against them. Courts have interpreted this provision to have two elements. First, defendants must receive notice of any criminal accusations that the government has lodged against them through information or other formal charge. Second, defendants may not be tried, convicted, or sentenced for a crime set forth in formal charge. The right to be tried in a timely manner. Number 1, in all criminal prosecutions, the accused shall enjoy the right to a speedy trial and public trial by an impartial jury of state where the crime has been committed. Number 2, a person's right to speedy trial arises only after the government has arrested, indicted, or accused a person of a crime. Before the point of accusation, the government is under no Sixth Amendment obligation to discover, investigate, accuse, or prosecute a defender within a certain amount of time.
4. The right to confront witnesses against you. The Sixth Amendment guarantees defendants the right to be confronted by witnesses who offer testimony or evidence against them. This is Confrontation Clause. The Confrontation Clause has two prongs. The first one, that the defendant has the right to be present during all stages of trial, allowing them to hear the evidence offered by the prosecution, to consult with their attorneys, and otherwise to participate in the defense.
The second prong, like I was saying, the second prong of the Confrontation Clause guarantees defendants the right to have their own witness in person and to subject them to cross-examination.
The rights of a person accused of a crime. The Sixth Amendment has specific rights for criminal defendants, including the right to be tried by jury, the right to be tried in a timely manner, the right to be informed of the nature and all causes of accusation against you. Now, I will explain these rights in detail.
Well, the Sixth Amendment contains a lot of the pieces of what everybody thinks of as a fair trial. So it's really just a collection of rights, like the right to have a lawyer with you, and the right to confront witnesses, which is really the right to cross-examine witnesses. And all of those rights together are intended to ensure that defendants get what we generally think of as a fair trial.
George Mason, one of the few founding fathers who did not sign the U.S. Constitution, had a lot of concerns about it as a document, which ultimately led to the Bill of Rights. Can you explain the history behind this?
The Bill of Rights was added on in order to ensure that the legislative power could not be used and the executive power could not be used to basically interfere with the rights that the founders were most concerned with guaranteeing individuals in certain circumstances. One of those circumstances was a criminal trial. The founding generation and its predecessors were well aware of abuses, mostly in England, and wanted to ensure that certain rights that everybody agreed were necessary to try someone fairly were explicitly protected. And that's the origin of a lot of the parts of the Bill of Rights and the origin of a lot of the individual clauses within the Sixth Amendment.
What were the abuses? What were they concerned about?
Well, there were many parts of the Sixth Amendment are aimed directly at those abuses. For example, it was not uncommon in the 16th and 17th century in England for the government to go out, interview somebody who is a witness to a crime, get an affidavit or a declaration or a recorded statement, and then come into court and just read that statement to a jury or to a judge, with no opportunity to talk to the person who actually was testifying. And the framers were concerned that that was absolutely inconsistent with the notion that the criminal defendant had a right to test the evidence against him. And so the right to confront witnesses is aimed directly at that concern. Similarly, in England, there was a long tradition, oddly enough, of not guaranteeing people's right to an attorney when they were charged with more serious crimes, sort of the opposite of what you'd expect. But in England in the 16th, 17th, 18th century, you had a right to have a lawyer on your behalf if you were charged with a trivial crime, but not a serious crime. The colonists always took the opposite view, and the Sixth Amendment was designed to enshrine that opposite view in the Constitution.
Which led to public defenders. Was it in part also, I'm wondering if because if you were poor, you couldn't afford a lawyer. If you were rich, you could get off maybe easier?
Initially, the Sixth Amendment right to counsel was not a right to a public defender. It was a right to go out and hire your own lawyer and be assured that that lawyer would be allowed to represent you in court. It wasn't until the 1930s that the Supreme Court began to address the Sixth Amendment in terms of the state's obligation to provide you with a lawyer. Actually, the origin of that right is a sad chapter in American racial history. The very first significant Supreme Court case on the Sixth Amendment right to counsel it grew out of the infamous case of the Scottsboro Nine. Nine African-American boys were arrested and charged with the rape of two white women. And they were appointed a single lawyer, and they were tried 12 days after they were arrested. And they appealed that conviction in part because they'd been denied the right to go out and get their own lawyer, and they'd each been denied the right, if they couldn't get their own lawyer, to have a lawyer. And that case went all the way to the Supreme Court, and for the first time, the Supreme Court recognized an absolute right to counsel, even on the state's dime, if you're charged with a capital crime.
Our phone lines are